Good afternoon, everyone. Please note the questions feature in the control panel if you have any questions or comments during the program, and we'll collect all those questions, and they'll either be answered during the program or afterward. And the orange arrow to minimize the GoToWebinar control panel is on the left there. We're proud to co-sponsor this webinar series with the University of Florida Levin College of Law Institute for Dispute Resolution. And today the webinar is Crafting the Effective Mediation Summary, a workshop. And here we have our presenters. Howard R. Marsee was a board-certified civil trial lawyer for 20 years until 2003. Since 1996, he has served thousands of hours as a mediator, arbitrator, and special master. He's certified by the Florida Supreme Court to receive circuit civil mediation appointments and by the U.S. District Court for the Middle District of Florida to receive mediation appointments in cases pending before that court. He's also approved by the Florida 5th District Court of Appeal as an appellate mediator. He is a former member of the Florida Bar Standing Committee on Professionalism and a current member of the National Academy of Distinguished Neutrals. Thomas G. Kane is our other presenter, and since 2000, Tom has dedicated his practice to dispute resolution, mediating more than 2,000 matters. He's been an attorney since 1975, but even before that, he assisted in the trial of 20 circuit court criminal cases as a law school intern for the Dade County State Attorney's Office. He began his law practice in Orlando at Driscoll, Conrad, Langston, and Layton, PA, a firm specializing in civil trial practice and personal injury defense, and he became a partner there. In 1985, he formed Thomas G. Kane, PA, which grew to a 9-attorney firm specializing in personal injury law at the trial and appellate levels. And now I'm going to turn the slides over to Howard.
All right,
Go ahead, Howard.
Good morning, ladies and gentlemen. Tom and I are happy to be with you today. You know, when I attend a seminar or webinar, just like you, first question I always ask myself is, who are these people and what qualifies them to talk to me? Well, tell you a bit about Tom and myself. The subject today, of course, is about writing. Tom and I have, between us, 98 years as attorneys. During that time, we've written hundreds, if not more than 1,000, mediation summaries ourselves. We've been mediators for over 48 years, and during that time, we certainly have reviewed thousands of mediations, some good, some bad, some ugly. We're both novelists. Between us, we've published 6 novels. We've written hundreds of legal articles for journals, law reviews, some legal, some historical. So we do know something about writing. And today we'd like to share some thoughts with you on the mediation summary, because we certainly have seen our share of the great and the bad and everything in between. I need to tell you that we can't give you any magic recipe today. You know, we can't say in paragraph 1 you put A, in paragraph 2 you put B, in paragraph 3 you put C. But what we'd like to do today is give you some consideration that you need when you sit down to write your mediation summary. And yes, mediation summaries are important. Tom will address that a little further later on. But they need to prepare the mediator, and if you send them to the other party, to educate about your case. As far as we're concerned, crafting a good mediation summary is an important part of being a skilled advocate. Before I was an attorney, I was a journalist and a teacher of journalism. And one of the things you learn, the basic lesson you learn when you enter journalism school, are the 5 W's and the H. Now, I don't have the H here, but the 5 W's are why, who, what, when, where, and the H is how. Every journalist, those are the things that need to go into your consideration when you're writing a newspaper story or a newspaper article. And I'm going to suggest to you the 5 W's. And we're not going to talk about how today, and we're really not going to talk that much about where. But the first is who, why, who, what, and when. You probably ought to simply jot down as a mnemonic device to help you when you sit down to craft your summary. Why? Why do you do one? What is your goal? So many media that I see simply go on without any seeming real goal. So you need to really think why you are drafting this particular mediation summary, not a mediation summary in general, but this mediation summary. No single recipe makes every cake. And your objectives are going to vary from case to case. And that's something Tom and I are going to try to drive home today. Every case is different. Every mediation summary probably ought to be a little bit different. So the devices again, why are you writing the summary at all? Who are you writing it for? What goes into it? And when do you put it into the hands of the people that you expect to read it? Having said that, I'm going to turn over the next section to Tom.
Good morning, everybody. I'm Tom Kane. Thank you so much for attending. I think the why is pretty straightforward. If you think about your practice, you're involved in advocacy. Every time I had a trial, I did a closing argument. I never waived a closing argument, and I use a closing argument for lots of different purposes. One of the purposes is hopefully to connect with one of the jurors, someone who would be receptive to the arguments I was making, would understand the case the same way I understood it, so that when they were back in the jury room, they would be able to advocate on behalf of my position. Well, the same is true with a mediator. When we're in the room with your opposition, I will be the devil's advocate. We need to be equipped to understand the case from your point of view. So the more information you give us, the better job you do in crafting your mediation statement, summary, the better job that we can do. Never waived a closing argument, and I certainly don't think anyone would waive an opportunity to advocate as effectively as possible on behalf of their client by submitting a mediation summary. In a good mediation summary, what I'm looking for is first to have an underlying of the essential facts. Now, there are cases where liability is not an issue, and the main FA is important in those cases. But still, to have things in context and to understand other topics that will come up during the mediation, I need to know something about the underlying dispute. I'm looking for, hopefully, have the issues set out clearly and succinctly, so I know what the dispute is. A statement that says my client was not guilty of negligence is very clear and very succinct, but it's also not particularly helpful. Because it doesn't give me anything but a conclusion to go back to the opposition. I need to understand why your client wasn't negligent, and or why your client's position is correct, or why the other side's position is fundamentally flawed and incorrect. It's helpful to identify who all the operating parties are, what positions they occupy, who's representing the company, what the company's position is, or what that person's position is within the company, who the parties are, and sometimes more difficult to be understand how they're interrelated. And you can help solve a lot of that by describing them in your mediation summary. Also, it's helpful So a string of citations to support your position doesn't help me a lot. But one or two cases that really sum up what your position is, if you provide those, I'm going to read them. I'll find them online and I'll read them because I want to understand the case from your point of view. That's part of my preparation. We'll talk about this more later, and I have mixed feelings about whether you ought to include your client's settlement position in a mediation. And I think my position may be different than a lot of mediators. I generally don't like to have it, but if you want to give it in broad ranges, I think that's certainly fine. And another thing that you can do with your mediation statement is to establish credibility, and not just with the mediator. You can establish credibility with your client to see how hard you're working on your case if you share the mediation summary with them. And if you allow the other side and their clients to see the mediation summary, you'll establish credibility with them. And it will also give you a chance to maybe help change their mind about the strengths of their cases. I think a good mediation summary allows you to effectively advocate for why you're right, but equally as important, why the other side is wrong. And if you can provide evidence and factual basis for those positions, you're going to put the mediator in the best possible position to advocate on your behalf. Howard, anything you want to add to that?
All right. Well, go to, all right, who gets the mediation summary is closely intertwined with questions of what and why. This is probably one of the most important points that we can make today. And that is that you simply can't look at who, why, what, why, and when in isolation. They are inextricably tied together. Who gets the summary may well depend on why you're crafting the summary. What goes into the summary may well depend on the intended recipient. That is, what may depend on who. In fact, I make a point here that's going to sound like one you've probably not heard before, but you may, in some cases, I don't think all cases require this, but in some special cases, you may consider more than one summary. You may want to send one summary to the mediator, one summary to opposing counsel, a different summary to your client. And we'll say a little more about that as we go on. But always remember, again, if I can make no other point today, it's the four W's are all dependent upon one another. Tom?
Yeah, well, while you're searching for it, the next slide asks the question: who should get the mediation summary? Slide number 8. What I would suggest is that this is a decision that is part of your advocacy on behalf of your client, and different cases with different circumstances produce different decisions on whether or not you would supply the mediation summary to other parties. Some summaries just should be kept confidential. If you feel that what you have to say is well received, that it might be considered harsh or confrontational, don't share that summary. Sometimes that information is better shared, filtered through the mediator. You know, some of the cases we deal with, as lawyers, we deal with people who are at conflict points in their life, but under the greatest pressure. There may be very sensitive issues such as sexual abuse or embarrassing family situations. And those are best kept confidential. But sometimes we have clients who aren't interested in settling. They've got a different agenda. They want a trial. Maybe they want a trial because they feel that the person has been punished enough in other forms. Maybe they want a trial because the point that they need clarified is just too important. I don't think anybody would suggest that Brown versus Topeka Board of Education ever should have been mediated and settled. It was too important a principle that had to be established. And those situations, you may not want to provide a mediation summary to your opposition. You will want to provide a mediator, but you may not want to tip your hand too much to the opposition. But absent some special circumstances such as these, I think that if you provide it only to the mediator, you've missed an opportunity to advocate on behalf of your client. You've missed an opportunity to create better understanding and to persuade the other side. I recommend to people that they send a copy of the mediation summary to opposing counsel with a copy for their client to review, especially that constitutional client where there are multiple people who have to make decisions. It really doesn't do any good to tell the mediator that you have a life care plan or there's a new surgery that's been scheduled if the insurance company doesn't know about it and they show up and they get blindsided. That's a mediation that's almost from the outset doomed to failure. But if you provide the information early enough, if you alert them that they can prepare, then you've set the table so that hopefully you can achieve a very good outcome for your client. Sharing also encourages the other side to share with you. And if parties aren't sharing their mediation summaries, I think that they face a different kind of a danger. And that danger is being caught unaware at the mediation with a new argument or a new point of law that they hadn't fully apprehended before. And I absolutely agree with Howard. I think it's totally appropriate to provide multiple and different summaries depending upon who your audience is. If you have a very intransient client, I don't know why you'd want to send them a mediation summary that advocates very strongly for his position. That person probably needs a more balanced and more objective summary about what the pros and cons are and the pluses and the minuses of going to trial. Not only does it help them get involved and start to think in more rational terms, but by having the information on the other side, it kind of inoculates them to whatever bad news or things they hear in the mediation. And if they hear that there's a problem from you and that gets mentioned as well by the mediator, then it suddenly becomes more credible. And I think the clients take it more seriously. I'll talk a little bit more about this on the slides that we have, but I really think it is to everyone's advantage to share their mediation summaries.
All right, what information do you include in the summary? Again, the content of the summary is directly dependent on your goal and who you're sending it to or who you expect to read it. For the mediator, we're going to be talking a lot about that as time goes on, but for right now, it's probably sufficient to say you want to let the mediator know the identity of the parties, the attorneys, the basic issues, status of the case, analysis of the issues, pros and cons. I won't go into all of those right now. For the opposing party, you want to be an advocate. You want to sell your case to the opposing party. And as an attorney, I always did one thing. I always, of course, we weren't dealing with email back then. We were dealing with snail mail. And I always sent an extra copy of the summary that I sent to the opposing attorney and said, here's an extra copy that you can give to your client. Remember that when you give a mediation summary to opposing counsel, this is your chance to get past the attorney filter. Up until this point in time in the case, the only thing his or her client knows about the case is what they've been getting from the attorney. Here is your chance to put a document in the hands of the claims adjuster or the plaintiff, depends on who you're representing, advocating your case. it may be the first time they've heard something other than the rosy view their attorney has been feeding them. And I'm going to be a little repetitious here, something that Tom covered, but I think it bears repeating. With your own client, the mediation summary you provide to your client, I suggest never provide to your client the mediation summary that you've provided to opposing counsel. At least do it with a great deal of thought, particularly if you're representing a plaintiff. With your own client, you want to provide a balanced view of the case. The pros, the cons, your chances of success, what happens if you lose, no rose-colored glasses. You don't want to create unrealistic expectations in your own client, because when you get to mediation, those will come back to haunt you. As a mediator, Tom and I have seen that time and again. When the attorney has been telling their client for 3 years, there's no way we're going to lose this case. And now when you get to mediation for the first time, they're having to consider, well, maybe there's some problems. So that's something certainly to consider. I've thrown this in simply because it's one of my favorite. You do not want your client for the first time at mediation to hear the bad aspects of the case. Make sure they understand going into the mediation that they have a balanced view of the case. Tom?
Slide is kind of touch on some of the considerations regarding the content. Touched on this a little bit. The content vary from case to case. In cases that are very complex, you might have to provide a lot of detail. In a more run-of-the-mill case, maybe not so much, but it's always helpful for the mediator to have something. Now, you may know that the case isn't going to settle because your client is insisting on a trial. This comes with the Board of Education concept. And if that's the case, that's fine. But again, to build credibility and for purpose of professionalism, I think it's important that you put that in the summary, and that you let opposing counsel know right away that this is a case that needs to be tried. But I think I see a lot of people who convince themselves, not that the case has to be tried from their point of view, but that it's going to have to be tried because the other side isn't going to settle. And I see a lot of people talking themselves out of fully participating in mediation because they think they've read the mind of the other side. And frankly, we never know what motivates settlements, what pressures are on people. You know? Some plaintiffs have mortgages that are due or children's tuitions that have to be paid. Maybe an adjuster's under pressure to close cases. Maybe it's the end of the year and an insurance company wants to bleed down its reserves for tax purposes. There's all kinds of things outside of the merits of the case that propel people towards a settlement. So don't ever assume that the case won't settle. By preparing a good mediation summary, you're putting yourself in a position to take advantage of those opportunities when they appear. Next issue is whether the summary be read by the opposing party. Well, certainly the lawyer, if they're doing their job, is going to read your summary. There's no reason not to if you provide it to them. And in fact, you should want them to. You should want them to understand the case from your point of view. You should want them to understand where their weaknesses are. And you should want their clients to see it as well. That's why I encourage you to send a second copy or encourage the attorney to share it with his client. As regarding the issue of whether you should send a copy to your client, I agree with Howard. A mediation summary that is strong on advocacy and short on objectivity is not something that you want to share with your client. It builds unrealistic expectations and makes your job and the mediator's job much harder. But once you've created one mediation summary, creating a different version of it the different advice and different insights for a different audience should be fairly simple to do. And I think that you should want to share that with your client. If for no other reason, your client doesn't see you working most of the time unless you're at a trial. They don't go to the hearing, they don't go to all the depositions. Let them see the work that you're doing so they know what you're doing for them. I think the effect on the client is it gives them greater appreciation for the skills and the art that you're bringing to bear to their benefit in the case. And it also helps educate them. You can accomplish so much sitting down with a client before mediation. I'm sure most of us do, and talk to the clients and try to give them the best advice we possibly can. But if they leave with a piece of paper that they can go over and talk about and think about, I think it's puts you in a much stronger position. Some people ask whether or not we can just send in a motion for summary judgment if that active summary. And I'll draft a motion for summary judgment. We'll touch on all the things that should be in the mediation summary. It should have the essential facts. It should have a summary of the procedural setting. It should have a summary of the law. But you're writing in a different style for a different audience. It may not be as helpful for your client to read it. It may not provide everything that you want in terms of some of the practical issues that we think may come up in the course of litigation. And generally, it's not going to be as objective as you need to be, trying to fully equip your mediator to be an advocate on your behalf. So in some situations, in an emergency situation, if you have to get something out, a summary judgment motion is better than nothing. But I don't think it's a full substitute for a well thought out, well crafted mediation summary.
All right. Content that you should consider including. Again, I'm just going to hit a broad overview. We'll cover this in more detail, but certainly you want to identify all the parties and their roles. You want to identify all counsel, any known mediation attendees, and enough detail to help the mediator effectively advocate your cause. Now, give you a little caveat here. That doesn't mean you provide only one side of the case for the mediator. If the mediator is going to effectively advocate your cause, he has to also know about some of the warts on it. So you want to give the mediator information to help him be an advocate for you, but you don't want to give him information that's going to let him be trapped by his lack of information with the other party. There's nothing worse for a mediator than going into a caucus and saying, well, you considered this, this, and this. And the party says, well, didn't the plaintiff tell you? Didn't the other party tell you? So you don't want your mediator to get surprised. And of course, you want a reasoned analysis that demonstrates your mastery of the law and fact of the case. One of the most effective attorneys I've ever seen at mediation did a remarkable thing. In his opening and sometimes in his summaries, he would look at the other party and say, look, I understand what your defenses are or what your claims are. This was a plaintiff's attorney. Well, I understand your defenses, but let me tell you how I'm going to get around those. So he took this right up front approach. And then when as a mediator, I would go into the room with the opposing party, they'd say, well, I'm not going to use any real names, but old Joe really knows his case. And there's no higher accolade than you can get and have the other people in the other room tell the mediator that. But to give you another quick tip that comes from journalism, I know that you all read newspaper stories, and when you do, you probably never thought about the structure. But journalists are taught on newspaper stories, not necessarily the soft human interest type stuff, but the hard news stories, is that you always write the story in a pyramid, much like the food pyramid. At the top of the pyramid and the very tip, you put in the lead, the very most important things in the case. And most of us, when we read a news story, we read that lead, maybe 1 or 2 paragraphs, and when we're done, we may not go further in the story because it's not of interest to us. But after that lead, you put in some of the details about the event, and then at the base of the pyramid, you put in background information. Next time you read a newspaper article, look at it and see if that's not true. Anything that's written by any of the wire services, AP or UP or Reuters, you're going to see that that pattern holds. Well, the same thing holds for a mediation summary. I would suggest to you that the pyramid form of doing the summary will be very helpful to you. I don't have all the time in the world to go through it today, but give that some thought. Tom?
So what are your client's goals when you go to mediation? It's important to remember that a mediation is not a trial. You're not bound by the relief that you pled in your complaint. It gives you an opportunity to be open to new ideas, to be creative, to come up with solutions in a way that maybe a court could not. And this is going to vary depending on the action. You know, if you're in a personal injury case, the issue is always money. In business cases, sometimes it's different. Maybe you have partners who have a dispute over business. Maybe there's a solution where one buys the other one out. Maybe there's a product that one wants to manufacture. Maybe there's a way to negotiate a license that will put an end to the dispute. I don't think it's particularly productive to provide a bottom line number in your mediation summary because, first of all, I probably won't believe it. Most mediators won't believe it. And secondly, it kind of locks in your thinking and you miss opportunities sometimes to either do better or fail to recognize something that you hadn't considered before that could in fact make sense. I'll talk about that more in a little bit as well. You know, as attorneys, under the rules of professional conduct, Rule 4-4.1, we're required to always be truthful in our statements to others. But the rule carves out an exception. Some people call it puffing. And what the rule says, I'm going to read it because I think it's important. Under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact. But we have this exception for puffing. But you'll hear me talk about credibility already today, and I'll talk about it some more because I think it's such an important aspect of mediation. You want to be credible. You want people to believe the things you say. And if you put in the mediation statement, especially if you're selling it, hearing it to the other side, and there's a $5 million policy and your demand is $5 million, and you have a soft tissue injury case, that doesn't help your credibility. You can do it. The question is, should you do it? On the other side, with serious injury, a de minimis offer indicate that the case has no value beyond soft tissue in your mediation summary that you've shared with the other side. Again, you put yourself in a hole, you ruin the credibility, and it doesn't necessarily have any effect at all on where you're going to wind up. At the end of the day, the case is worth. Sometimes there's obstacles to settlement, special problems, and it's important for the mediator to know these things. If you have an unrealistic client, the mediator needs to know that. It doesn't necessarily have to be in the mediation summary. We all have telephones. Pick them up. It's so helpful and regarding part of your mediation summary to have this conversation ahead of time with a mediator to let them know. I've had cases that I thought were pretty meritorious, but through the course of several hearings, I've come to understand that for whatever reason, the judge doesn't get it. He doesn't like my case. It's just unimpressed with my position. And if you're experiencing that, I think it's important for your mediator to know that as well. There may be pending appellate cases that you're monitoring that might be dispositive of your position. If you're aware of those, I think it's important that you share those with the mediator. Client control issues. Again, this is never something that you want to put on a summary that you're going to share with the mediator with the other side, but client control issues are significant impediments to settlement, and the earlier the mediator knows that's an issue, the earlier the mediator can start thinking about ways to mitigate that problem. And again, if you don't want to put it in the summary of the mediator, pick up the phone. Insurance coverage or solvency issues are also things that you may want to address in your mediation summary. If there are multiple parties and there are multiple layers of coverage and there's a dispute among the parties, the insurance company parties, as to whose coverage applies and when it applies and how it applies, if those can't be resolved before the mediation, hopefully they can be, it's important that everybody has a copy of the policy, that the mediator is aware that there's going to be a mediation within the mediation. There's going to be mediation between the plaintiffs and the defendants, and then there's going to be a mediation between the defendant insurance carriers over whose coverage is going to apply and how it's going to apply. Solvency is a little bit different issue. And I think, especially in business cases, it's something that you need to give some thought about too, and that you need to share with your mediator. If you have a meritorious case, it's going to wind up bankrupting the defendant. The meritorious case really isn't very meritorious, which is no way to collect the defendant. So you may want to consider more creative solutions. You may want to start suggesting those to the mediator. Something like installment payments or in-kind payments. Maybe a situation where one side or the other acquires the business so that they can keep it solvent. Or you may want to think about what business relationships are going to exist in the future between the parties. Or in a family situation, what are the interactions going to be between these parties as time goes on? Lawsuits come and go. Families last forever, hopefully. Businesses go on for a long time, hopefully. We want to make sure that as part of the mediation, as part of the settlement, that we don't set these relationships up for failure down the line. And you can help the mediator address those issues by the things you put into your mediation summary. The status of the discovery and the pleadings also can have an effect on the negotiations. If we're very early on in a case and all the discovery hasn't been completed, there may be a reluctance to engage in a meaningful settlement negotiation. If you need information before you make a decision, let the mediator know that. The mediator can help facilitate that. The mediator can call the other side and say, hey, listen, I just got this mediation summary, and I think that for there to be any success, you're going to have to provide A, B, C, and D to the other side so that they can understand it, appreciate it, and analyze it before we get into the discovery. Same thing with pleadings. If the pleadings aren't set, sometimes it's hard to negotiate a settlement. If there are still outstanding dispositive motions, if there's still outstanding motions to dismiss, mediator needs to know about that, and we're going to provide them in the mediation summary. If on the other hand, the notice for trial has been sent out, and we're anticipating trial being set for the next couple months, again, the mediator needs to know that. Cases that are closer to trial have different dynamics than cases that are still in the pleading stage. And that affects how the negotiation is going to get conducted. The more of that kind of information that you provide to the mediator, the better job the mediator can do for you. Howard, what do you think? Any other considerations about the content?
All right, some more content. First, any special provisions or contingencies that the settlement agreement must address. First, I'm going to start with a basic proposition that before you ever go to a mediation, you ought to have a pretty good idea of the form that the settlement agreement is going to take. And the terms that the settlement agreement you would like are going to contain. I think it's a real advantage if you prepare a settlement agreement, even if it has blanks to be filled in, and take it with you to the mediation. Maybe even put it on your laptop if you take a laptop to mediation. And one reason you want to be the drafter of a settlement agreement, if you can, by taking one to the mediation, you give yourself a leg up. The reason you want to do that is the laziness principle. You're going to find in life that people try to avoid work wherever they can. By drafting the agreement, there's a higher likelihood that the other party is going to use your agreement than to take the time and the effort to draft their own. So I suggest that you take an agreement with you, but if you can't do that, at least make very sure you understand any special provisions. And you may want to include that in your summary to the mediator. That is not the agreement itself necessarily, although you could do that. But at least tell the mediator, if not the other party, maybe both, it depends on what you're trying to do. But we think any settlement agreement has got to contain, well, for instance, a confidentiality clause. That seems to be the vogue now. No matter what case you settle, everybody wants a confidentiality clause. But any special things, it just has to be in the agreement. You probably need to let at least the mediator know that. You also need to let the mediator know whether partial settlement is an option. It may be the case that you're not going to settle everything. Maybe you can settle the breach of contract count, but you can't settle the fraud count. Well, discuss that with the mediator. And again, it may be a subject you do or do not want to discuss with the opposing party in whatever summary you send them. Is structured settlement an option? I think it's always helpful to know if you're representing a plaintiff and your client is a mother with a brain damaged infant. I think it's helpful to let the mediator know that you would consider a structured settlement, that is, an annuity payable over the life of the child, because sometimes that's the only way those cases get settled. The background of past negotiations or mediations. I personally, as a mediator, want to know that. I don't know that you need to tell the other party in whatever summary you send them, but certainly I think the mediator finds that helpful. At least I do. In fact, I always put at the top of my, I usually, when I mediate a case, I have, if it's one plaintiff, one defendant, I'll have two columns. Plaintiff's proposals in one column, defendants in the other. And the first thing I put at the top is the history of negotiations. It's always amazing how many times the parties have forgotten what proposal they made 8 months ago or what proposal the other party made 6 months ago. And you have to be careful as a mediator telling them that if they don't already know it, but at least you know what's gone before. Key developments that may affect the parties' respective risk. Maybe there's a new case that just was decided by the 4th DCA. That case is going to impact your case considerably. Well, I think the mediator needs to know that, whether you want to educate the other party yet or not. A lot depends on your philosophy, and a lot depends on whether you need to use that as a at the mediation as a last ditch effort to settle the case. But those are tactical decisions. But at least the mediator needs to know that. So those are some things in the way of additional content. Some things you should not put in. In fact, one of the pre-webinar questions we got online today was, what should I not put in a mediation summary? Well, here are a few. You certainly want to avoid ad hominem attacks on parties or counsel. Now, for the mediator's eyes only, probably, if you and the other attorney just hate each other, then maybe the mediator ought to know that. But I don't think you need to call the other attorney a scumbag, particularly in the summary to him. Personal attacks don't really get you anywhere in a mediation, or over-the-top hyperbole or exaggeration. Some people are just prone to exaggerate. Misstatements of fact or law, or overly rigid declarations of positions, invectives, throwing gasoline on the fire. My favorite all-time story of throwing gasoline on the fire is I was in the room with one caucus, and this attorney who, it was obvious the attorneys hated each other, but this one attorney, and I'm cleaning up the language, but said, "You tell them to go to hell," in the other room. And of course, as a mediator, I walked into the other room and said, "Your last proposal was not well received." But, that's part of the job of a mediator, is to clean up the communications. But things like that are not helpful, certainly reduced to writing. In fact, I can tell you sort of a personal story. I am special magistrate for a city here in Florida. And on my desk now for an upcoming hearing is a motion to dismiss a case in which it's filled with personal attacks on city officials. It's filled with sarcasm. It's filled with exaggerations. There are outright mistakes of law and fact in it. I can promise you that type of thing doesn't endear you to anyone. Now, the mediator, of course, is getting paid to endure you, if not adore you. But certainly, these are the type of things that you should avoid, I think, putting in a summary. Remember, you're reducing these to writing. Someday they could come back to haunt you. Tom?
Thank you so much. Yeah, I agree. Temperate language in a summary is very important. We want to avoid ad hominem attacks, want to avoid effective. These things say more about the writer than they do about the target. This doesn't advance the cause anyway. So, on to the issue of when do we send the summary? A couple months ago, I got a fantastic summary. Very comprehensive, very well done. It had a very extensive summary of a very complex case from all the parties' point of view, with highlighted excerpts of the deposition, contracts of the dispute set out in bold type. There was a brief on the case law. There was photographs. There was a lot of moving parts in this case where they presented a case list, a cast list of who all the people were and what the roles were and what their positions had been. And it was just fantastic. There was two problems with it. First problem was over 700 pages long. And the second problem was it came as an attachment to an email 2 hours before the mediation was supposed to begin. So as wonderful as it was, that provided very good consistency. Less than 2 hours to try to skim through it and very quickly might be important. So my suggestion on when do you send the summary is send it on a timely basis. The bigger it is, the earlier you need to send it out. I like if I get them at least a week ahead of time, but quite frankly, in most cases, I'm not going to look at the mediation summaries until the night before the mediation. And the reason for that is mediations cancel so frequently. I just don't want to put the time and effort in if I'm not going to do the mediation. And then it's reset and I've got to do it all over again. And now I'm double billing people. I like to do the work that's going to be fresh in my mind and I'm going to be ready to go. So if you get it to me a week ahead of time, I can plan how much time I'm going to need to do it. Now, if you're good enough to share your mediation summary with the other side and you want the other side's client to review it, especially if it's an institutional client, I would say push that window back a little further, maybe 2 weeks out. And if it's 2 weeks out, that gives the other side an opportunity to get it to their client. And if there's new information in it, if suddenly there's a care plan or a new economist or a new surgical recommendation, then the insurance company can claim committee it and they can be prepared at mediation to deal with the actual case you have, not the case they thought you had. If you wait till the day of the mediation to share that information, if you don't put it in the mediation summary that you share with the opposing counsel, then instead of using the summary to set yourself up for success, you set yourself up for failure. Mediations like that rarely wind up well. Parties cancel. They want to adjourn the mediation. They want to have more time to look or do more discovery. So I think you do yourself a favor if you get it out earlier. You expect that the other side is going to send a copy to his or her client? Well, you can't control, if they're going to give it to the other side, you can't control what they're going to do with it. So I think you have to expect they're going to send it to their client, and that may affect how you draft it, the things that you say, and the activity bring to bear, and the that you try to establish through the use of this mediation summary. I think you shouldn't want the other side to send it to their client. Client not to be surprised in mediation. They need to know what warts are in their case and how you're going to exploit them so that they can appropriate steps to protect themselves. And settlement. The complexity of the case factors. Obviously, if you have a case that warrants a 700-page summary, get that to the mediator early. I'm not going to read that the night before. I'll start reading that in the week before the meeting. Study it. I'll make notes. I'll create my own outline and highlights of it so that I have a ready reference and access into your document to the preparation that the next topic goes to the mediator is going to get involved in the case prior to the formal mediation session. And the answer to that is absolutely. And sometimes as a mediator, I'll initiate that. I will pick up the phone and say, I've read those summaries. I see this, that, and the other thing as kind of important issues. Can you fill in the blanks for me? What am I dealing with here? But there's no reason you can't pick up the phone and call the mediator. The phone call is always welcome, and it's almost universally helpful to help the mediator be prepared, not only with your summary, but with some clarification of your summary and to be apprised of things that maybe you don't want to put in your summary. I just can't emphasize the importance of making phone calls, getting the mediator involved. These are not ex parte communications. They are mediation rules, and in fact, they are encouraged. It gets us to the point where we can move effectively towards the settlement of things we ought to be doing. And then how about your own client? They need time to digest the summary. Again, there is not one answer to it. Clients are going to be at different education levels, different levels of emotion, different levels of sophistication. You'll need to decide with each client, first off, whether you want to give them some version of your summary and how much time they're going to need to digest it and be prepared to have a meaningful. I can be on the same page about what can be accomplished and what the goal ought to be. And if you can do that, then you have a yardstick to measure the progress that you're making in mediation, whether you're making good progress that you can do or not. And the summary will help set you up for success if you can get that kind of information to the mediator.
All right, Kathy, why don't you advance to the final slide, and I'll take some time to answer some questions. Okay, can you do that? Okay, we do have some questions. I'll just hit a few because we are almost out of time. The first question is, how much time should I expect the mediator to charge for reviewing the mediation summary and preparing for the mediation? Well, the short answer is they're going to charge you by the hour. I don't know of, there may be some mediators who don't, but all I know charge by the hour. So it depends on what you give them to review. If you give the mediator 3 spiral-bound notebooks to review, and then you're probably going to be charged for that time. A question that's probably unrelated, but I think it's worthy of answer is, how successful are remote mediations? They've proven very, very successful in the age of the pandemic and Zoom. I find them very effective. I find most attorneys love them, most clients love them, simply because they don't have to travel nearly as much. They get more work done. Should pre-suit summaries be different in the way they are structured? And if so, how? I really see no difference. I think we discussed the other questions. So Kathy, I think we'll leave it up to you to give them the CLE information, CME information.
If you're a Florida attorney, please jot down the Florida Bar course number so that you can post your CLE credit online. It is 210-8924-N as in Nancy. Again, that's 210-8924-N as in Nancy. You can see the contact information for both Howard and Tom on this final slide. And I also wanted to let you know we are building our webinar schedule for the remainder of the year. Next, we have Arthur Garcia presenting an attorney's mediation toolbox on March 18th. Thank you all.
Thank you, everyone.
Thank you so much.